Hello and welcome to our webinar 2022 Mid-Year Law Updates, Everything You Need to Know to Make Your Practice Compliant, presented by HR for Health. My name is Taylor Harris and I'm the PR and Content Specialist and your host for today. Every year, new laws take effect while others expire. During this webinar, our HR for Health co-founder and renowned employment attorney, Ali Aroumtian, will walk you through the law updates that have taken effect in this first half of the year, as well as bills to keep an eye on. He'll explain exactly what you need to know to keep your practice compliant and avoid legal risk in the rest of 2022. If you have any questions, please enter them at the question and answer box, and we'll try to answer them at the end of the webinar. If we don't get to your question today, don't worry, we'll follow up with you as soon as possible. Without further ado, Ali Aroumtian.
Thank you, Taylor. Hi, everyone. Welcome to our mid-year update. This was one of our most popular webinars the past couple of years, and so we wanted to bring it to you again and go through all that is happening in 2022, as it's been a busy year. It's been a busy year. Honestly, I can't even believe it is almost July, considering how fast this year is going. But it's really about being ready, right? And the reason we say that is that there's a lot of rule changes that are occurring, a lot that's happening sort of behind the scenes, and we'll talk about some of those bills that are being passed in various states. But there's also a lot that is being done that has occurred or that is already in play that you may or may not know, due to all the sort of the craziness that has already happened in 2022. And I know a lot of you are doing well in your practices and are busier than ever. And so it's been hard to keep up with a lot of these new things. But between what the legislatures are doing in various states in the background, without a lot of news updates on that, without a lot of headlines, things that are going to impact you, we're going to talk about those. We're going to talk about things that, like I said, that have already come in play that we need to kind of go through, and so we'll go through those in detail as well. There's going to be a lot of questions that you're going to probably have as we go through all this. Of course, we only have about an hour, and so we can't go into any real great granular detail, but we will hit on a lot of things today. And so if you have questions, please make sure you ask them at the end, or reach out to us after the fact, and we will walk you through whatever needs to be answered so that you're familiar. As most of you know, and as Taylor mentioned, this is all I do. I help doctors nationwide with their practice acquisitions, practice sales, of course, employment law, and estate planning. This is one of the reasons why I enjoy doing what I do, which is to be able to educate everyone on these topics. And the goal of today is really not to make you an expert on all the different rules that are coming out, but rather to give you the power and the ability to raise your hand when you feel like something is wrong, or more importantly, if you feel like there's something happening in your state and you're not sure how to be compliant with the HR laws and you're not getting your support from your payroll company or otherwise, that's when you come to HR for Health if you're not already an HR for Health client. Because we know that there's a lot going on, and if you don't have experts in the field to answer your questions, you're going to be left out in the cold. So make sure you raise your hand, make sure you ask for help, especially as we go through the rest of the year. So the topics we're going to talk about are the legal updates, as I mentioned, and then some friendly HR reminders that we still see come up over and over again as pitfalls for most of our doctors. These are things that are getting you in trouble, getting you sued, or getting you in some sort of administrative hearing. It's not your fault, quite honestly. A lot of you who are not HR for Health customers are relying on, unfortunately, resources that are not there to necessarily hold your hand through the whole process, and you probably feel that way already. And so our goal is to kind of remind you of those things so that you can start thinking about how to putting them in play. And of course, if you need help putting them in play, that's what the entire HR for Health team is here to do. So right off the bat, if you have your phones handy with you, take a picture of this QR code. This will give you a detailed white paper on the checklist issues that we're going to go through. This is sort of a mid-year checklist, if you will. If you're listening to me or watching me on your phones, don't worry, we will send this to you as well. Just communicate with us, and we can send it to you if you can't take a picture of it on your phone, because you're on your phone. So there we go. All right, so let's jump into it. Let's talk about the legal updates that we need to be aware of that is happening right now. So right off the bat, there are a lot of minimum wage updates occurring throughout the country, and they're not getting the same press, if you will, as other things that are happening around our country. And so it's really, really important that you look into your state and local laws regarding the minimum wage increases that are occurring, because some of them are very, very significant. There are counties and sometimes cities throughout, let's say our home state here in California, that are above $15 an hour as minimum wage. And as many of you know, there may be you have employees who are earning around that or less. And so it's really important, right? It's really, really important that you get your hands on this. And sometimes people make the mistake of just looking at the state rules and thinking that the state rules trump everything, but they don't, as you probably know. The state rules are, of course, important, and those will be in effect. But if your county or your city has their own rule, then that rule regarding the minimum wage dollar amount will trump the state ones, especially, of course, if it's higher, which it usually would be. So it's really, really important that you look into this, because you may have to up some of your employees' hourly rates to account for it. And so just kind of keep that in mind. Also, if you have if you take your team to off-site training programs, if you have a consultant that has an off-site program, every once in a while you might go once a year, twice a year, take everyone there. You can definitely have a second rate of pay for those off-site training programs. And so if you don't have that, it's a good idea to put that in your employment manual, or you can ask us and we can help you kind of put that together, of course. But remember, they have to be off-site, so anything in your office, they get paid their normal rate. But if they're going to another city, another area, or whatever, you can certainly try to do that. And remember, it just has to be at least minimum wage, and you're okay. So, all right, now tied to increases in minimum wage are updates to various notices that you have to put in your offices. These are, posters and other kind of things that the state always sends and asks you to post up in sort of a public area or somewhere where your employees can see. So let's talk about a couple of them that have already kind of gone into effect. California has one where they require the posters to also be emailed to the employees, and so kind of keep that in mind. In New York, and this, by the way, went into effect on January 1, 2022. New York has a rule that was effective on May 7th that required the notices to be provided to all employees, along with acknowledgements that if some sort of electronic monitoring is going to be used. So if you have cameras, software on the computers, things of that nature, you need to do that. Of course, if you're already an HR for Health client in New York, don't worry about that. That's already in our handbook. But for many of you who are not, if you're using somebody else's manual, please double check that, because it may not be in there, is the experience that we've had. In Connecticut, on July 1st, that's coming up, actually, it's, what am I saying, it's today. The requirements to provide written notice of PFMLA rights is something that you need to do and provide to your employees, so just kind of keep an eye on that. And there are some other bills that are being passed in states like California that would give employees notice, for example, of monitoring tools, things that track their use of their computers or technologies used to monitor them. And so just kind of keep an eye on those things. Are out there in states like California, and many others are passing those rules now or are about to. And so if you are monitoring your employees, you may you may need to do that. There are some prohibitions there regarding facial recognition and emotion recognition tools with regard to monitoring systems. So we haven't seen that in healthcare, but I can imagine people using it. So just kind of keep that in mind. And any monitoring after hours is not allowed of personal devices. So if it's a work device, that's a whole different story. But if it's a personal device, just kind of keep that in mind. Okay. All right. We talked about this. You're going to see a lot of these bill alerts, if you will, throughout the presentation today. Again, these are things that we are expecting to pass that are sort of in various legislatures around the country. This one is the one that I was just talking about in California regarding monitoring. So we'll expect to see that. All right, let's move on to hiring and onboarding. Many of you are hiring like crazy. You are working really hard to either fill empty spots that you have, or your practices, have grown, thankfully, and you need to hire more and more people for that. And so there are now different rules for the hiring and onboarding and documentation requirements for your employees. And so please keep these all in mind, depending on what state you are. Some states like California, as of January 1, have prolonged the document retention policies of employment records from 2 to 4 years. Now, those of you, of course, on HR for Health, you don't have to worry about that. It's all, stored for you electronically. It's safe. You don't have to even think twice about it. For those of you that are still doing things on paper, please be careful about those. If an employee leaves, you don't just shred their stuff. You have to keep it for 4 years. And that, by the way, that isn't just their employment documents that you might have when you're onboarding, which most of you hopefully have, the 12 to 17 documents, but it also includes payroll records, it includes time clock records and things of that nature. So make sure you have all of that. In Oregon, they have a rule as of January 1 as well, where you can't require an employee to have or to present to you a driver's license unless driving is part of their job, right? Is the essential part of their job. And so for those of you who may be running into some of these issues, a good question during the interview is, look, hey, this job is from 8 to 5 Monday through Thursday. Is there anything that would preclude you from coming to work on time? Do you have transportation? Those are good questions to ask that would reveal, somebody would reveal themselves if they said, what, I don't have a driver's license, or I have to take the bus, or this or that. And maybe that's an issue for you. We had a doctor not too long ago who hired somebody, moved them up from another state, actually paid for moving expenses or whatnot, and then found out that the employee, even though they only lived about 40 minutes away, had to take 3 different buses to get to work and never came on time, just never could make it on time because of the hours of the office, which were just your normal sort of 8 to 5. But the way the bus schedule was, just the employee could never come on time, and that caused real stress. So just kind of keep that in mind, and just kind of know that those are okay questions. If you have any questions about what to ask during an interview, let us know. We have some awesome materials on our website and other places where there's some really good questions that you can ask, and some questions that maybe you shouldn't ask. So just kind of know that. All right, in New York, as of May 15th, you have to, if you have 4 or more employees, you have to let them know what the minimum salary is and the maximum for all job posts. So kind of keep that in mind as you're posting these jobs. In New Jersey, if the same basic rule applies, except now you also have to do you have to also indicate what benefits are there. So just give that some thought. These are, again, things that are in place when you're hiring and onboarding. All right, now another bill alert. There's a couple of things happening in Florida and Texas that's really important for all of you to know. So in Florida, there's restrictions on workplace training, with regard to diversity and non-discrimination. So as of July 1, if you have 15 or more employees, and this is really important for many of you, because if you're part of a group practice, an MSO, a DSO, or you yourself, 15 employees is not uncommon for many of our clients. Just remember that these documents need to now be in place in Florida, and you need documentation. You need to do some training on diversity and non-discrimination. So just kind of keep that in mind. Again, hugely important. In Texas, the threshold is 25 employees. It used to be 50 employees, but with regard to E-Verify requirements, again, we can house a lot of these in our in our system. But just make sure that if you're doing E-Verify, and you weren't doing E-Verify, if you have 25 or more employees, you do need to do that as of January 1 of 2023. Okay, so you have some time, but not that much. All right, now total new withholding form updates in some states. Now, as many of you know, the states throughout the country are divided into kind of two worlds. You have some states that provide their own withholding forms, and then some states that rely on just the federal withholding form. So again, I'll give you an example. In California, you have the federal withholding form, and then you have a California withholding form that each employee needs to fill out, indicating how much money is going to be taken out of their paycheck, for taxes and other things. Well, historically, you had a state like California, or you had what we call the federal states, and these states don't have their own federal forms. They just rely on the federal one, the one that the IRS gives, and so on and so forth. That is starting to change. So now, we're starting to see a movement where a lot of these federal states are now having their own forms, and they're kind of tiptoeing into it a little bit. Like, for example, Colorado, they have an optional withholding form that's very state specific that you can use starting January 1, and needs to be completed or whatnot. And this is, again, in addition to the federal form. It's called DR0004 or DR4. Just kind of keep that in mind. But other states have jumped totally into it. So Hawaii has it, Louisiana. These are states that now have their own forms, and they have some specific uses for them. Like, for example, in Louisiana, if an employee is not a resident of Louisiana but works for a practice that has 25 or fewer works for a practice for 25 or fewer days, then they don't need to use this form, but otherwise they do. And so again, there's some minutia to this that you need to be aware of. We can't get into all of it, of course, in every state, but just know that between Colorado, Hawaii, Louisiana, there are these states that are federal states are turning into more of with their own forms, are turning into state-specific states. And then on top of that, the federal W-4 withholding form is changing, or has changed, and there's a 2022 version. So again, hugely important that you update that. Of course, if you're already an existing HR for Health client, you don't have to worry about that. But for everybody else, please do make sure you keep an eye on that. And that is a perk of HR for Health, for those of you who are not customers yet, is that we maintain all the up-to-date state-specific withholding forms in our software, and they get updated automatically, so you don't have to give it a thought. You don't have to reach out to anybody. It's just, it is what it is. All right, another bill update. In California, there's a prohibition against employment discrimination for marijuana users. Woohoo! And so just be careful of that. If you are, if you believe that you may, have employees that you're looking to hire, or that are marijuana users, or if you're looking to terminate somebody, you're going to have to be a little bit more careful. This still has to pass both houses, and the governor only has until mid-September to veto it. But we believe that it could pass. Of course, if somebody comes in high to the office to work on patients, there's definitely things you can do to let them go. It's just that you can't discriminate against them. But just give us a call if you ever face this. Don't do this on your own. I mean, there's a reason why we say come to us for these kinds of things. Okay, all right, another big change here in California, and we do expect this to happen across the country because this is a big deal. In terms of settlement agreements, if you are in a lawsuit or administrative hearing and it's around sex-based discrimination or harassment, then there are new things that must happen with your settlement agreements, okay? And primarily what the goal is with these is that you can't have the employee sign a non-disclosure agreement that doesn't allow the employee to disclose information or unlawful acts in the workplace, okay? And so these are really important. They need to be drafted very carefully. This has started in January of this year, and so it's just important to kind of keep in mind if you're going to give non-disclosure agreements to employees, even outside of settlement agreements, they have a right to disclose information regarding sexual discrimination or harassment. So just be careful about these. Make sure you have a lawyer sort of review them as they are very important. And then tied to this, and remember what I was saying about those laws kind of that occur in California to expand across the country. This is a really good example, right? This is a good example. Restrictions with non-competes and non-solicitation agreements are changing also around the country. And here you have states, like California, where non-competes and non-solicitations are typically illegal, and then you have some states, like Atlanta or whatnot, or Atlanta, Georgia, where it's not as illegal. Well, those things are starting to change, and what we're seeing is places like California have now rules that say you can't require employees to sign a non-disparagement agreement or other document that denies the employee the right to disclose information about unlawful acts in the workplace. And some of you have those, right? And so, but in Illinois, for example, they had set forth rules on specific ways where these things can be valid and enforceable. If you don't follow those rules in Illinois, then they're not, valid. In Oregon, again, they do the same thing. They set out terms on when these kinds of agreements are valid and enforceable, and you got to sort of follow them to make sure. In Washington, there's earning requirements. So now if your earnings are a little bit higher, then these kinds of things are maybe not as enforceable, and so we got to kind of think about that. And so again, the rules are changing, right? The rules are changing, and it's changing very frequently. In Colorado, there's a couple of bills coming out that are making restricted covenants more restrictive. In August of this year, if the governor signs it, then most non-competes in Colorado are going to be invalid or void. And this includes sort of highly compensated employees as well. Trade secrets and all of these things may, these issues come up. So if you have a non-compete in Colorado, it's important to kind of talk about them and decide and look into whether they're still valid, come August, and do they need to be revised in any sort of way. In Washington, D.C., businesses are prohibited from requesting or requiring employees to agree to non-competes. Again, there used to be some reasonableness standard there that has changed now. So again, things are changing. So just kind of keep that in mind with those kinds of documents. Okay. All right. Another bill alert in Colorado. We talked about this a little bit. If the governor signs it in August, most non-competes are going to be void and with highly compensated workers. Non-solicitation agreements would have the same sort of issue. So keep an eye on that if you are in Colorado. We talked about some of this as far as Washington, D.C. Again, the federal rules are also changing, actually, because of the Me Too movement. Right now, they're effective March of this year, there's a prohibition against arbitration waivers for sexual harassment and assault claims. So in other words, you can't force someone to go to arbitration, for those kinds of things. Again, good things because this information can get out. It's not, private like many arbitrations are. So again, these rules are there. All right. So some things with the EEO, across the country, it's important. In Minnesota, they've broadened the requirements for pregnancy-related medical leave. And lactation policies. And so again, if you're in Minnesota and you have employees who are pregnant, or if they are lactating, then you need to accommodate them. You can't reduce now their compensation for time to express milk. Again, really important. In Tennessee, there's some military protections that are in place now, where veterans can observe the entire Veterans Day as an off day. It's unpaid, but it is a day where they can have off. There are some exceptions, I should say, for this. So kind of keep that in mind. If you have any questions, let us know. But they do have to give you notice and prove that they're a veteran. But this one we don't necessarily expect to kind of grow across the country to other states, but it's a nice thing, and it is an unpaid day. Many of you close on Veterans Day anyhow, so maybe it's not as big of an issue. But for those of you who do not, then it could be for sure. All right, wage and hour law changes are occurring as well. This is an exhausting one because it feels like every 6 months we have new rules that come out regarding wage and hour. In California, as of January, there's this sort of whole rule called the intentional wage theft law, where if you don't pay your employees correctly, and you're deemed to have done it intentionally, then there could be severe penalties for you on top of other penalties that are there. It can be considered grand theft, if more than $950 is kept from any one employee or independent contractor, or I think $2,300 for more than 2 people, then it can be considered grand theft. And this is something where you as the owners could be liable, and also office managers who are responsible for payroll and whatnot could also be liable. So just kind of keep that in mind. Illinois, specifically Chicago, has sort of a similar type of rule, where there are fines if you don't pay someone correctly as far as wage payment, if you don't have posters, record keeping, if you retaliate, and things of that nature. So for those of you who are not using our timekeeping system, please, that is one of the many tools that we have at HR for Health that is so valuable, so strong, and can keep you out of harm's way because of the record keeping. And so we've been ahead of the game in timekeeping for years and years. We've really led that revolution. So it's not just about clocking in and clocking out, it's about all the other things related to it. So if you're using your practice management software, please move on from that. That is so archaic these days. You've got to move to a much more sophisticated system like ours that ties benefits to the time clock system to make sure that you are completely safe in a holistic kind of way, as opposed to just keeping track of time, which is super silly. All right, let's move on to some mental health changes. We do expect these to kind of grow around the country. Kentucky is leading the way as of January. They require all mental health to be considered and treated in a similar fashion as how physical health conditions are treated. And so what that means is that there could be disability issues, there could be long-term disability matters that you need to deal with. There could be discrimination issues that we need to work through. So just kind of keep these in mind. There are bills in various states where mental health is becoming more and more of an issue amongst legislatures. And so we do expect this to kind of grow, across the country. Now, tied to that, sick leave is also changing. Sick leave is also changing. Last time when we did our New Year webinar, you saw me kind of talk about some of these states, but this has grown, as you can see in New Mexico and whatnot, and some other local regions like West Hollywood. But in Colorado, paid leave law, paid sick leave law now applies to small businesses. If you're less than 16 employees, you got to give 48 hours of paid sick leave. In Bernalillo, New Mexico, effective on July 1, there's an increase on the accrual cap for employees or employers with 35 or more employees, from 44 to 56. Okay, so hugely important. In West Hollywood, paid sick leave takes effect. It's another area in California that has its own special rules, and now eligible employees can take up to 96 hours of paid sick leave there in West Hollywood. Again, super confusing because you got the state rules, sometimes you've got the county rules, and then you've got you've got the local rules like in California, New Mexico, and Colorado, and some other states. The good news is that we keep track of all of that for you when we figure out where you are, so you don't have to worry about it. Family leave laws are also changing and have changed, pretty extraordinarily this year. There's in California, the CFRA, which is the California Family Rights Act, was amended to expand the definition of what a parent is. So now it includes parent-in-laws, if you will. This is going back to January 1, by the way. In Oregon, family leave provisions amended the definition of the benefit year. So a 52-week consecutive week starts on the Sunday before the date when the leave begins. And so again, just small little changes to kind of keep in mind. In Rhode Island, temporary caregivers have increased their leave from 4 to 5 weeks, for family leave. In New York, there's been an amendment where paid family leave can be taken immediately and intermittently, so they can take it in portions over time. Again, hugely important. In DC, there's a maximum leave allowance for parental leave, family leave, medical leave, and those have increased. And so again, in Washington, Colorado, I mean, these things, as you can see, have changed a lot. I mean, in Colorado, they created a whole new program, called the Paid Family Medical Leave Insurance Program, I think, family or family, I don't know how to say it. So they have a whole new thing, and those premiums are due under that program starting in January of 2023. So if you have any questions about these, make sure you're reaching out to us, because again, huge changes. All right, because of the issues with retirement that came up during the pandemic, a lot of governments around the country have seen that that the reality is that people have not saved enough, and so now they are pushing many employers in many states to have their own 401k plans or other kinds of programs. In California, the deadline was June 30th, where employers with 5 or more have to register for CalSavers. If you're on this webinar and you're in California, you should never sign up for CalSavers unless you really don't have any other options. For most of you, that is like the Deni-Cal version of retirement. If you are in California, you should be really signing up for a profit sharing plan, a 401k plan, something of that nature, because one, you get to put away a lot more money for yourself as the owner, and then you also contribute to your employees. But because these contributions are tax deductible, you're really saving a ton of money by doing it this way. And so we highly recommend that you reach out to our team at HR for Health for our 401k options. They are by far the best in the country, the lowest rates you will find with the best service. And so we've negotiated an incredible deal with a couple of third parties, and we're passing all that on to you. We're passing all of it on, just like we did with payroll. So this is, this is the time to do it. Don't let the summer come and go without you really focusing on this, because there are going to be penalties if you don't provide this to your employees. Illinois has this, has the same rules that are starting in September. Registration begins for their plans, between 16 to 24 employees in September of this year. September of 23 is going to be employers with 5 or 15 to 15 employees. So again, be ready for that. Oregon has had a plan for a long time, actually since 2019. If you have 5 or more employees, you need to be there. And then Colorado, same thing, 5 or more employees, you need to have. Your some sort of retirement plan. Again, HR for Health is awesome. Again, we've negotiated it to such a low degree. We haven't had anybody beat our rates. And so make sure you take advantage of it, because it's just thousands and thousands of dollars in your pocket that's going into the pockets of these 401k companies and financial advisors that you could be having for yourself and for your team members. Remember, it's an awesome tool for retention, right? An awesome tool for retention. All right. Let's talk about some health insurance updates that are occurring. These plans are very complex, and they can vary one from another. They can be very, very different. And so it's really important that you speak to your brokers and insurance providers on this. It's not a sexy topic, and a lot of insurance brokers don't even want to do health insurance. And so we've been getting a lot of comments and complaints about their insurance brokers or whatnot. And so what we did is we kind of put together a list of some really good ones that our clients have told us give a really high service level. And so if any of you have any questions about this, you want a recommendation, just reach out to our team, and we can plug you in with someone that can take care of you on the health insurance side. I know it's not a fantastic thing, and because these health insurance companies, by the way, don't pay the brokers very much for the policies, they're not getting the brokers aren't giving the service, unfortunately. And so that's why we went out and we found a group that probably is going to continue their reputation and keep doing good work for you. So, all right, lastly, before we go to the reminders, there's some whistleblower protections that have now in place in New York, effective January of this year. There is expanded retaliation protection for those that report unlawful or dangerous business practices. So if you do report these, you are protected from retaliation. There is this belief that there's some secrecy behind it, and they'll keep your identity secret. That doesn't really happen. Everyone ends up finding out. So just gotta know that. That's why I think these laws change as far as retaliation, because even though it's supposed to be confidential, employers were finding out and then retaliating against employees. So there you go. So the new laws are in place for that. We talked about California's whistleblower, some things related to that regarding non-disparagement or whatnot. But again, these rules are, we believe, going to expand nationwide, because as a country, as a community, we want people to inform the government if there are things not going well in the workplace. And so that's why these laws are changing, rightly or wrongly. Okay, let's switch gears and talk about some HR reminders, some things that we still see be problems for our doctors nationwide. This is about learning from other people's mistakes, okay? And many of you may be making these mistakes, and that's okay. Don't feel bad, but just commit to changing it, right? Commit to changing it. Commit to having a better kind of program, a better life, a better, stress-free kind of experience with your HR. And it starts with these like super basic things that you need to kind of keep in mind. And of course, we're here at HR for Health to support you through that. Paid holidays, there are a couple coming up. Obviously, 4th of July is next. And then there's Labor Day. Please make sure if you look at your manuals and you figure out whether or not you're giving these days off to your employees. If they're paid, make sure you take account of it in your payroll system. If you're an HR for Health client, you can easily assign these benefits, to your employees, avoiding, miscalculations and manual calculations and all of that. And so kind of keep that in mind. That's coming up. It's a good idea to do a periodic job analysis for your team, and just making sure that their exemptions and classifications are correct. Are they exempt or are they non-exempt? Are you supposed to be paying overtime or not? Kind of keep that in mind. Are you paying them per diem? And if you are and they're non-exempt, are you paying overtime? We had a case just on Monday with a client who had a office manager who was answering phones and doing a lot of other things. They were paying her a salary, but she wasn't really an office manager. She was really the front receptionist doing office administration type of work, but doing it only like 20% of the time by the doctor's own admission. And so they had gotten some bad advice from a company that does employment manuals, and they had put her as an exempt employee, and there you go. Right, there you go. So just kind of keep in mind that you have to make sure your employees are classified correctly. So, and what I would start with the ones that you're not paying overtime to, and decide, are they truly exempt, right? And do they fit these rules, right? Do they manage people? Are they paid on a salary? Is it double minimum wage? Is it all these other things? Remember, as minimum wage goes up, these rules change, right? So you have to kind of keep that in mind, and of course, kind of reach out to us if you have any questions. If you have any associates who are independent contractors, then you definitely need to reevaluate that. This is becoming more and more of an issue nationwide than ever before since COVID. The federal government, a lot of states are really, really coming down hard on employers that hire independent contractors. Still the chance of getting caught is still lower, but it's becoming a much bigger number because they're being audited, in various ways. So kind of keep this in mind. But remember, this is really the only person in your office that could potentially qualify as independent contractor, is a doctor associate. Maybe, right? Even that is sometimes hard to prove. Nobody else in your office, right? No RDA, no hygienist, no optician, no tech vet, nobody, right? Regardless of what kind of doctor you are, would qualify as an independent contractor in your office. The only person would be potentially an associate. And that, when I say potentially, that's a huge asterisk around that, because as I mentioned, rules are changing and it's becoming harder and harder and harder. We know there's some consultants out there who are still pushing this, because they don't want you to pay payroll taxes and all this kind of stuff. But then you're getting audited, and then you're paying penalties and fines and all this, and those, and so it's just not worth it. If you have questions about it, just kind of reach out to us. All right, some documentation that you need. Make sure. We're still in a COVID world, although it's becoming, hopefully less of an issue, but we are still in the COVID world. So make sure you have vaccination policies, declination forms, your proof of vaccination in your employee records, documentation for any testing requirements. All of these things need to be handled very carefully. In your new hire checklist, make sure that your documents are very state specific. If you've gotten a checklist from a payroll company or someone who does, a company that creates an employment handbook for you, they're not going to have it, right? We've seen it from our clients. They've sent it to us. They're not going to have it. Make sure you get, your state requirements in there as well, and that you have all that in place. Performance management violations, performance reviews, make sure you're doing all of those. You got to have your handbook, time clock. We talked about this. Please get an electronic one like ours. That's IP specific, hugely important for your safekeeping. Okay. All right. And as we end, most of you know about HR for Health, but if you don't, just give us a try. Let our team kind of show you around and see if it's a good fit for your practice. We give you an employment manual for free every year that's updated to you. That in of itself is a $2,000 to $4,000 savings. Some of these other companies that do employment manuals and pretend like they do other things too, they're charging you a ton, right? And we're giving it to you as part of our service, as part of our dedication. We're doing payroll better than anyone and cheaper than anyone. It's all electronic, and it's becoming more and more streamlined as we go. So give that a try. Of course, you've got our HR support, almost 24 hours a day, unlimited. You can call our HR team and ask them any question you need. If they can't answer it, or it's a legal question, they will refer you to a law firm that will take care of you there and answer your questions and help you. And so you've got a lot of support, lot of support. Make sure you get all your documentation, because at HR for Health, we believe that is your first and best line of defense. So make sure you have all your documents, all the new hire forms, and everything else. Our time clock is just amazing. We've led the way in that for years. So please make sure you're taking a look at that. And then the best tool for retention and improving your employees is performance management, and all the things that we've got there with annual reviews and whatnot. Our team can show you how to do those effectively. Remember, it's not just about being compliant. It's about being safe and having the peace of mind to know that you can focus on your business without worrying that someone's not being paid correctly or someone doesn't have their documents and they could come back and sue you. No one really talks about it, but there's a lot of cases out there, and it's easy to fix. It's easy to be compliant, and we help you do that. So give us a shot, and let's see if it's a good fit. Our team is ready to help you. For those of you that missed it early on, this is our QR code again for the mid-year law update checklist, and so feel free to take that. And for those of you, as I mentioned, if you're on your phone and you can't take a picture of the QR code, then just reach out to us and we'll send it to you. No problem. Just make sure you let us know that you attended the webinar. All right, and so thank you guys very much. Here's our website, hrforhealth.com. I appreciate you guys. I hope you have a wonderful and safe holiday for 4th of July, and look forward to speaking to many of you the rest of this year. Be safe, and we'll talk soon. Taylor, do we have any questions?
Yes, we do. We have quite a few questions. So we only unfortunately have time to answer 2 of those. The first question is, since there is a new withholding form available for my state, should I have my team update their current form?
Yeah, that's a great question. So as we talked about earlier, there's a lot of new forms being issued by states and the federal government. And so you do not need to update your existing employees' forms if you don't want to, unless the employee needs to update their withholding. Now, I use this opportunity as a good excuse to update all of my documents with the team. So if you want, this is a good opportunity for you to use that and say, okay, guys, we need to update all of our forms, and then you can give them all new forms and make sure that everyone's signing everything. It's easy to do if you're on HR for Health. If you're not on HR for Health, of course, it's not as easy. So there's no requirement, Taylor, unless someone needs to update it.
Fantastic. Okay, so we have one more question. Then last question for today is, if my state now has a new sick leave requirement, when do I need to provide it by, and what steps do I need to take in my practice?
Yeah, great question. So if your state has a new sick leave requirement that's already in effect, then you need to provide it now. And if you haven't been providing it, let's say the sick leave rule went into effect on January 1, you have to, and you haven't done anything, you have to backdate the data. So you have to figure out what they would have earned going back to the beginning of when it went to an effect and calculate it accordingly. And if they took time off and it wasn't paid because you didn't do what you were supposed to, then it's okay, just kind of fix it, and so it's available for them, and then we can work through whether you should pay them or not to take that into account. Remember, it's important to do it so that the employees don't come back and say that they never got it, even though they were entitled to it. So there's a little bit of work, but our team can help you with that.
Absolutely, absolutely. Well, thank you everyone for joining us today. Remember, if you didn't have your question answered today in our question and answer box, we'll reach out to you in the near future to answer those questions for you. And I hope everyone has a wonderful holiday, and thank you all so much for joining. Have a good one, guys.
Thank you. Thanks, Taylor. Bye.
Thanks. Bye.